RFB Legal. The Litigation Series.
Hi there, my name is Patrick Trevor. I am a solicitor in the litigation department at Ronald Fletcher Baker. Now, my talk will deal with the issue of adjudications and the sort of general procedure that an adjudication will follow once commenced and the situations in which they might arise, most commonly, of course, in the context of a construction project. By their very nature, construction projects are long, lengthy, they're technical, and often very, very expensive. If a dispute was to arise during the course of a, let's say, 3-4 year contract on a construction project, the parties would not want those works to be, or the relationship to be, underpinned by ongoing court proceedings, which would ordinarily be the method parties would use to resolve a dispute in the event they weren't able to settle the issue via alternative means through sort of joint meetings or a mediation or what have you, which themselves are of course expensive. Now, adjudication offers an alternative method for the parties to resolve such a dispute, importantly in a timely manner. Ordinarily, you'd be looking at adjudication being turned around within 28 days from the date which the referring party submits what's called a referral notice, so statement of case or the facts upon which it relies. Most commonly, or the simplest route commencing an adjudication, is through what's called a smash and grab adjudication, which often concerns payment notices, so a party claiming payment of a particular sum, ordinarily at the end of a month, provided a contract provides for interim payments, which is more often the case for cash flow reasons. With these smash and grab adjudications, a procedure which the courts have recently referred to as the short contractual route for payment, due to their timely, sort of time-efficient, quick turnaround with the means of resolving a dispute which arises under a construction contract. There are various requirements to commence an adjudication and what's required in order to commence an adjudication. One particularly pertinent fact to mention is that an adjudication can be commenced in circumstances where the parties haven't signed a contract, or if in fact there is no written contract at all. The subject of an oral contract could not be referred to an adjudication process and the law wouldn't step in. However, that all changed, and as a result, predictably and somewhat unsurprisingly, the amount of adjudications increased as a result. Whilst you have all the multi-million pound projects going on which are being carried out pursuant to JCT contracts, big, thick, written documents, there are other contracts that are being carried out on more informal basis, whether that be as a result of a meeting between Party A and Party B, and no written terms are necessarily agreed. The terms of that agreement would be incorporated into an oral contract by way of various discussions between the parties at the outset of the works, such as when payment is due, the final dates for payment, as well as how any disputes arising out of that contract. So taking the most classic example of when a dispute is likely to arise in a construction contract, and that is parties' entitlement to payment. Now, ordinarily, you'd have a situation whereby Party A is required to submit a payment application at the end of each month. Now, so Party A does that, it's carried out various works, it's been valued, and Party A claims payment. Depending on the terms of the contract, say in this example, Party B, so the payor, would have until the following calendar month, the last date of that calendar month, to pay the sum claimed by Party A. In the event Party B disputes the amount being claimed by Party A, it has the option of serving a pay less notice. And again, without going into the legalese and the requirements for a valid payment notice, pay less notice, essentially what such a notice ought to encompass is the grounds on which Party B disputes the sum claimed by Party A. Now, if there is a situation where no pay less notice has been issued by Party B and the final date for payment has passed, so Party A has not been paid any of what it's claiming in its payment application, Party A, subject to sort of contractual terms and of the circumstances of each case, would on the face of it be entitled to commence a smash and grab adjudication to claim payment of the sum for that particular month that Party B had failed to pay. In terms of the procedure that a party would follow, they'd be required to draft the notices of intention to refer the matter to an adjudication, and 7 days thereafter they'd be then required to submit the referral notice. Now, the referral notice essentially takes the form of the pleadings of the case. So Party A claiming payment would say, we've carried out these works, which has been valued by this, which has been carried out in accordance with the contract, the terms of which a payment would be made by this date. They haven't been, therefore entitled to payment of this sum. Taking this common example, that dispute would then be referred to the adjudicator, and the responding party would then have 7 days in which to submit its response. So it could argue that for instance, a chain of emails amounted to a pay less notice, and therefore party A's entitlement to claim that specific sum is not engaged. Touching or harping back to the point about the timely process for an adjudication, after the service of the responding party's evidence, the adjudicator would then be required to give his or her decision within 14 days of the responding party's evidence. So it's a very, very quick, snappy procedure. And one thing for the parties to construction contracts to really bear in mind is the importance of keeping written records and making sure payment notices comply with the various statutory requirements. That if you're a party on the receiving end of a payment application and you're not content with the sum being claimed, or you dispute any amounts that a party is claiming payment for, then the pay less notice needs to contain the requisite information. Now, given circumstances where court proceedings could take anywhere from 18 to about 30 months, 2.5 years to conclude, obviously that's likely to carry on throughout the duration of a construction project, which itself might go on for 24 months, 2.5 years, 3 years, however long. And a contractor and employer obviously wouldn't want to conduct those works being underpinned by litigation. It could make the commercial relationship fractious, which is likely to be the case, and could end up to either party, it's likely the contractor, actually walking away from the project, which might have disastrous consequences for that particular project. So therefore, adjudication, very quick, very snappy procedure to follow. It's worthwhile just touching on one point, given the current circumstances around the world in relation to the outbreak of COVID-19. The courts are still very much in favour of adhering to these the strict timeframes imposed by adjudications. There's a recent case of Mill Hill Development and Waters of April this year, where Mill Hill was seeking an injunction to stop the adjudication process. There's a dispute over whether a site visit was required to take place, and the court held that no injunction was granted. The parties knew the timeframes that they were required to adhere to, notwithstanding the lockdown restrictions, maybe which are sort of restricting the parties obtaining certain information, hard copies and files or whatnot. And the court rejected that, the argument for an injunction. So the motto of adjudications is very much pay now and argue later. They're a very quick, timely fashion of dealing with disputes which might arise on a construction project, and we here at Ronald Fletcher Baker we've acted for both employers and contractors, subcontractors in these sorts of procedures. Thank you for taking the time to listen to this talk, and I hope you found it informative. Thank you very much, and goodbye.